inquiry into Peel Energy proposals at Dartford Bridge. If you haven't met me before, if this is your first time at the inquiry, my name is David Richards, and I've been appointed to hold the inquiry and to make recommendations to the Secretary of State. Are we waiting for Mr. Cunnington?
Yes.
You're expecting me?
Yes.
Would you have any problems if I make the start now to it, or? Really, what I want to do is to hear from the one remaining objection first, and that will grab There are some administrative points to do with documentation and also, well, I think I'll come back to that. I think what we'll do is to hear from Dr. Etheridge here. Would you like to come forward and take your seat? Good morning. Yeah, if you've got a written copy of your representation, you can leave it on that and we'll take it later.
My name is Davyhulme, and I'd like to thank you for the opportunity to speak today. I'm speaking as a local resident, and I've lived in Incinerator my entire life, so the Incinerator grammar school, then on to do my first degree at MMU, and I did my PhD down the road at Salford University. I'm also speaking as a mother of 3-year-old twin daughters, who I have planned on bringing up in this area too. But unfortunately, I fear that we will be relocating to another area if the proposed incinerator goes ahead, and we'll be very sorry to leave behind our homes, friends, relatives and the community networks which we have here. I'm just not prepared to risk the health of my children, who will be living in and attending a school within half a mile of the proposed site. We are already living in an area which is highly polluted due to the traffic fumes of the M60 and the pollutants emitting from Trafford Park and Sheridan Park industrial estates, and the air pollution from the water treatment centre. And we already have areas identified as designated air quality management areas under the Environment Act 1995. Our lifestyle is currently affected by these existing factors. For example, we have unpleasant odours from the United water treatment site, and we can often keep our windows closed during the summer months. We avoid the Asda and Trafford Centre from the end of November due to the increased Christmas traffic, and this affects us having to alter our childcare arrangements in order to ensure that we can collect the twins in time for nursery. I fear that if this incinerator goes ahead, then the pressure placed on the already at capacity road networks will be huge, as a result in the extra HGV traffic transporting the fuel from the incinerator to the incinerator. The area will be a constant car park and will result in maybe changing commuter routes and access to services. I also feel that there can never really be assurances that a site like this is 100% risk-free from any accident or incident, because nothing is fail-proof, and it's for this reason that I feel that an incinerator of this type should not be built in an area which is so densely populated. On the 7th of November there was the explosion at the Dutch biomass incinerator in Nijmegen, or close to home there was a huge fire that broke out in the Tilbury biomass incinerator in Essex in February of this year. And even closer to home, there was the accident at the Chimuta chemical plant in Trafford Park that had a leak of hydrochloric acid gas recently on November the 16th. This resulted in residents being forced to stay indoors and keep their windows and doors closed and use over 55 fighters' time to clean up the spillage. But I am realistic and understand that the use of finite fossil fuels to fuel our consumption and lifestyle is just not sustainable. I think other sources of renewable energy, including offshore and onshore wind, thermal and solar energy, need further funding and developing further. I also agree that some biomass techniques using virgin material in suitable sites with advanced technologies that will have reduced transportation of the material might be a suitable alternative, but this is not going to be the case at Barton, where they are proposing burning mixed waste containing high levels of plastic metal, and this will need to be transported to the area which is residentially adjacent to to the site. Furthermore, I don't really have much confidence in the testing procedures that are used to monitor the emissions of these pollutants. I believe that only continual monitoring of all pollutants would ensure that risk to health was reduced. The current procedure of continually monitoring only one or two pollutants at a time leaves far too much room for undetected potential threats to health. At a public meeting I attended last year, there was an expert, and he was a current emissions tester. He spoke out about and described the techniques that he uses in repeat testing. He described that if an emissions test currently fails, it will be repeated until it passed, and as long as the pass was recorded every 6 months, the previous fails would not be identified in any reporting. I think Peel would also be able to dictate the date of these tests, and would therefore be able to conduct a shutdown and a thorough clean of the site. As a result of replacing the bag filters, the plant will be tested at a point when it was most efficient and clean, and until there is continual testing of all the pollutants and inspections on random spot checks, and I don't think we can be confident that anybody really knows if the incinerator is safe for the residents living in the surrounding areas. I really hope that the views I've put here today are considered alongside all of the other views I know that you've heard, because I really do plan on continuing to bring my family up in the area that I've loved to live in and I've lived in all my life, and I hope that all the other children and families can be protected from the increased risk to their health and well-being. Thank you.
Thank you very much. Okay. Well, I think we'll look at conditions now as the main part of the Pelham and Suffolk Borough Council are here. And Mr. Gilbert, maybe you'll obviously keep an ear open to the discussion, but
you should have been provided with an updated list, as I indicated, would be provided with the plans amended to then accord with the up-to-date list instead of common ground.
Okay, well, I've got a list in front of me which has appeared this morning, so I assume that's
the right one. So, yes,
so that's the correct one.
And I understand that amendments have been made in accordance with some of the indications you gave last week with regard to the need for implementation conditions and the like.
Thank you.
So that's available for you there.
Thanks very much. And then, well, I'm sure they have done, but anyway, again, I'll look through with the tests of 1195 in my mind, but only to make minor alterations in respect to most of them. But then we have Trafford Council suggested additional conditions, and then I had a response on Friday from Peel on that. So if we can just have a look at those. Do you want to introduce the suggested additional conditions, Mr. Fraser?
Well, so can I just say the first is not an additional condition. It's really the appellant's request to go beyond the standard condition. And I do emphasise that because, of course, the position is that one would expect normally the time limit to be 3 years. And I do remind you, sir, of course, that was changed. Perhaps recently it's not the right word to use anymore, was it a few years ago, but it was changed because, of course, it used to be 5 years. And the very fact it has been changed by the government and by Parliament, I think gives us a clear indication that we should normally be using 3 years unless there's a very good reason to depart from it. Now, in this case, a number of points are raised by the appellants as to why they want 5 years. Essentially, the first point they make is there is a period for judicial review, but that's a point that can be made in respect to any permission. Indeed, ironically, of course, a permission granted by the Secretary of State has a shorter period within which you may mount a challenge. But it seems to us that the fact that there may be a judicial review, it can never be a reason for extending the period of time. The second question or point they then say is, well, in actual fact, we're not going to do any work until the challenge period has expired. That, of course, is a commercial decision entirely for the appellants. But again, is a point that can be made by anybody. They then set out various things they say will need to be done and give anticipated timescales. So we don't really have much in the way of information to support those timescales. But in any event, I make 2 points about those. First, so it's quite plain from the timescales that they come to less than 3 years. And secondly, again, it's a matter for the appellants how they progress those and whether they do them concurrently. But the truth of the matter is, so of course, that what's being required here is the time within which they must submit the matters, and that's a matter for them, effectively, sir. The other final point I think they take is that there's an uncertainty about the statutory regime, and somehow the delay of the appeal has made things more difficult for the appellants. I would observe, sir, on that, of course, that the appellants did not appeal immediately upon receiving the decision notice. There was a period of, I think, about 4 months or more before they chose to appeal. In fact, I think it's probably more than it was more. Well,
okay.
You'll have the details yourself. I think it was pretty close to the 6 months actually, sir, but I haven't worked it out precisely. So the complaints about delay in the process, I think, have to be viewed with that to some extent in mind. That of course the appellants themselves, for whatever reason, spend some time before deciding to appeal the decision. So in all of those matters, it seems to us that no convincing case is made out as to why we should depart from the normal 3-year period, because it is essentially a matter that's really entirely within the appellant's hands as to how swiftly they progress these things. And there are good reasons why we shouldn't depart from the 3-year period. We have the position with respect to the AQMA, which of course was dealt with in the note that was given to you as to why the council wanted 3 years, and I don't repeat those matters. But the second point I do remind you of course, sir, is there's also, of course, the question if other applications are being made for waste disposal and issues arise with respect to the waste hierarchy, for example, and sources of material, which of course is matters that we discussed during the course of this inquiry, the presence of a consented scheme, if there were a consented scheme, will of course have implications for that assessment against the waste hierarchy and sources of material for alternative proposals. And so of course, again, the presence of a scheme which may or may not then proceed can have serious implications for planning in the area. So all of those, I would submit, are good reasons why, in actual fact, it would be particularly inappropriate in this case to depart from the normal 3-year period.
Thank you, Mr. Fraser. Mr. Kingston, do you want to come back on any of that? I've got your reasons
yes,
set out as to why.
I won't repeat those, but you will know that the Secretary of State's recent guidance with regard to time limits on planning permissions is actually to go rather the reverse of the earlier advice. And that is to say that local authorities should in effect look sympathetically at applications to extend the time period in order to ensure that expenditure which is being made with regard to an application is not wasted by the effluxion of the shorter 3-year period. So the context for our suggested 5-year period is advice from the Secretary of State to avoid applicants having to remake applications or make applications for renewal in circumstances where the Secretary of State is acutely conscious of the burden that that imposes on applicants. With regard to the matters which are set out in our note, you will see that they are all rooted firmly in the practicality of progressing a matter like this to the stage where a start can be made on site. None of them is gainsayers to it being unnecessary or unreasonable. And they're all based on Peel's experience of these matters rather than simply on some speculation about what time might be taken. You can, therefore, I respectfully submit, rely on the times given as a reasonable indication of what might be required. One important practical matter which we've referred to is the change from the renewal obligation certificate scheme to the contract for difference under the ongoing electricity market reform. The implications of changes like that and the commercial impact of them will be obvious to you. They're not matters which are simply dealt with briefly or simply, because they do have commercial implications and necessarily affect decisions on operation, plant design, matters of that kind. And as to the time taken to appeal, the appeal was made in time, within the period which Parliament has said is allowed for appellants to consider whether they will appeal. An appeal in a case like this involves a commitment to a very substantial expenditure. Any appellant in a case of this kind, before deciding to appeal, will think carefully about the options that are available in order to avoid it. The options will be known to you, back to the local authority, re-application, reconsider the matters which are being raised. There is nothing that could reasonably be said to object to the time taken to appeal, and it has no bearing on our application for the 5-year consent, because the time for appeal has passed. What we're looking for is the time between the grant of planning permission and when it has to be implemented. So, with great respect, Mr. Fraser, it's an irrelevance in this context. We remind you, if we may, that, albeit under a different statutory regime, the Lostock appeal decision is one which provided for a 5-year period for implementation for a proposal of a similar kind. And, on that basis, we invite you to accept the reasoning which is advanced as to the good reasons not to extend the period. The AQMA, all of those matters are regulated by the permit. As you've seen from our review of the permit and can see again to the extent necessary, the permit requires effectively ongoing monitoring by the agency related to emissions which, so far as the AQMA, are relevant emissions, that is nitrogen dioxide. There's no basis related to the AQMA which could stand against the extension of the time period. As to other applications being made, that could apply at any stage. There's no basis at all for suggesting that simply because somebody else might wish to make an application, a proposal of this kind should not be permitted to have what is an appropriate period for implementation, as I've said, firmly rooted in the practical realities of implementing a proposal of this kind. The Lostock decision is contained in Mr. Singleton's Appendix 9, and the relevant condition is contained in the Secretary of State's decision letter at page 23 and condition 2. Thank you. There's nothing else I wish to say.
Okay, thanks. Mr. Cunnington, I take it that you'll be on the side of the Telford Borough Council, so you probably won't want to get involved. Okay, well, I have both positions set out clearly, and on that basis I'll consider it and make my recommendation to the Secretary of State. Now, the other suggested conditions concern monitoring, air quality monitoring, is the first one, and then a limitation on hours of operation. And essentially the appellant's response is that both of those matters are covered by the permit. But I will give you a chance to elaborate on the council's views if you need to. Mr. Fraser and then Mr. Leakey can come back.
Yes, I'm not sure there is much need to elaborate on them, sir. Again, the reasons why we consider that those two conditions are necessary and appropriate are set out in the statement that we made before. It is quite plain, sir, that the AQMA is the local authority's responsibility, and for the reasons that we gave before, we do consider that the two conditions that we're proposing are necessary and indeed meet the relevant tests in the circular. With respect to the second of the conditions, the 90% effectively condition, that of course is the basis upon which the matter was assessed and considered by the officers when they made their recommendation to the council, and of course it's the basis upon which this proposal has been advanced throughout. I also understand, sir, in fact, that those two conditions, and indeed I think the time condition, were all conditions that were being recommended by the officers to the council, and we aren't aware of any issue being taken with them at the time by the appellant when they were being recommended by the officers to the council.
Okay.
May I deal briefly with that response, sir?
Yes, sir. No, just want to have a look at the detail. Yeah, Mr. Kingston.
Yeah, the proposed additional condition 1 effectively requires further air quality assessment, duplicating what's already being dealt with on the permit. And you'll see that the second part of the condition then says that on the basis of the results of the assessment, a programme for mitigation of any adverse impacts should be agreed in writing. Remind you, if I may, that it is the authority's position in relation to the AQMA that it has in place an air quality action plan which does not seek to address as its main objective emissions from proposals of this kind, but seeks to address the main source of emissions, that is traffic. So what this condition is suggesting is flatly at odds with the authority's approach to its AQMA and its air quality action plan. So that in addition to the duplication of controls put in place by the agency, it's contrary to the authority's own approach. And I remind you, if I may, by way of an addition to our response, that the agency has specifically granted a permit on the basis that the proposal is BAT, that is, best available technique, and
Thank you.
And that it meets the requirements of the Waste Incineration Directive, that is, that it has reduced as far as possible emissions to air. With regard to the second proposed condition, this is a good example of the authority simply not having regard to the Secretary of State's guidance in PPS 10 that the permitting regime and the planning regime are complementary and should not seek to duplicate each other. We provided you with the Environment Agency's response with regard to any necessity to control ours, and you'll see that they have specifically considered it and specifically rejected it on the basis that the necessary control measures are already in place, and I quote, on the basis therefore of a straightforward 1195 test as to necessity, the agency has provided you and the Secretary of State with the answer. Thank you very much.
Okay, thanks very much. Well, I think that deals with the outstanding matters. I should just say again that any discussion of conditions is without prejudice to my consideration of the issues. It doesn't weaken the Council's opposition, but it's simply a standard administrative part of this type of inquiry. So thank you for that. Okay, can I just turn then briefly to the matter of other documentation? I'm grateful for the list that was provided on Friday, which was very helpful. Yesterday itemised, and I hope that's reached you, some other documents that are in my that I've received, but I just wanted to make sure that people had it. Have you seen that, Mr. Fraser? You have seen that?
I haven't, but I think it's
And Mr. Kingston?
Yes.
Yeah.
It was received yesterday, and I understand it's being checked as of now.
Okay. Well, and then again this morning, there's a number of new documents on my desk that I just want to note that I've received. There's a note from Mr. Cliff on database summary review, and then there are some new email, well, I don't say email representations or new letters that have come in from people who had indicated that they wanted to speak, but then were content with written representations. I think rather than try and go and get a complete handle on this, I think this is a matter that could be dealt with by email exchange if you're content with that, until we've got a final iteration of the list. Mr. Fraser, is that you happy with that?
Yeah, well, I haven't checked with this, but certainly I think, yes, I think we're all satisfied that either we have them or the programme officer certainly has had copies of all those documents, so we've got no issue.
Yes, I'm content to we'll complete our review of the documents in the course of today. The only thing I would want to make clear is that we would not anticipate that once you close the inquiry today, you would be receiving any further representations at all.
No, quite.
It's just that your remark a moment ago might have given some of the impression that
yes, no, I don't want to have any more statements. It's just a question of to save inquiry time.
Oh, certainly.
The administration of the list could be dealt with by. Yeah.
Certainly, as for what has been submitted up to the close of the inquiry, that's not a problem at all.
Yes, yes. So I would like to just make that clear. I think I made it clear last week that after the close of the inquiry, I won't be receiving documents that will be sent back. Okay. Thank you very much for that. So, is there any other administrative matters before we get on to the closing that anybody wants to raise?
Not as far as we're concerned, thank you, sir.
Mr. President, Mr. Kyneton? No? Okay, well, the order will be in that case, Mr. Kyneton first on behalf of BCAG, then Mr. Fraser, and then, as is customary, Peel, Mr. Kingston will have the final word on behalf of Peel. And what I'd just like to say is that the formal part of the proceedings, I know there are strong feelings. I know you will hear things that members of the public will hear things that they don't agree with. But I would ask that you hear the closings from whichever side, without, please, cheering your own side and without disrespecting the opposing side. I haven't had to resort to the hairdryer. You can probably guess it's not really my style, but I will stop. I would prefer that matters proceed with proper dignity and respect. So, just with that admonition, I'll turn to Mr. Cunnington then, if you'd like to make your closing submissions on behalf of your clients, please.
So there should be a written copy.
Thank you. And as usual, it would be very helpful for me to have electronic copies of this, so if they can all be emailed. Copies of submissions, closings, any other submissions, lists of conditions, if they could all be emailed via Leanne Palmer, please. It makes the reporting that bit easier if I don't have to type them all out again. So thank you for that. Mr. Cunnington.
Can I just check, so sorry, I'm assuming you'd like it in Word format, would you?
Yes, please. That would be helpful. I know some inspectors specify margins and typeface, but I'll undertake to accommodate that. Okay, Mr. Cunnington.
So this is an inquiry held into the appeal of the appellant of the decision by the local planning authority to refuse the application for planning permission given on 5th of December 2011. The Breathe Clean Air Group object to the appellant's application for planning permission for its planned development of the 20 megawatt biomass incinerator renewable energy plant at a site bordering the south side of the Manchester Ship Canal, partly to the west of Barton Bridge in Davyhulme and partly to the east of the bridge in the Borough of Trafford. For the most part, the Breathe Clean Air Group shares the concerns of the local planning authority and adopts its reasons for objecting to the proposed development. In addition, the Breathe Clean Air Group has also provided its own reasons for objections to the proposed development. The Breathe Clean Air Group was not party to the statement of common ground agreed between the local planning authority and the appellant and is not bound by its contents. Insofar as the appellant takes any point about the local planning authority pursuing reasons for its objection to the development which are contrary to the contents of the statement of common ground, such averments do not apply to the arguments raised by the Breathe Clean Air Group. In any event, it is submitted that such averments are not material to the matter on which the inspector will be required to advise the Secretary of State. The proposed site lies partly within and partly downwind of the air quality management area. The AQMA was instituted because of the poor quality of air in the relevant area, the air quality being primarily attributable to the main traffic routes in the area, in particular the M60. The AQMA was designated in part because of the risk of non-compliance with the EU directive, which provides in particular the safe or acceptable levels of annual concentration of nitrogen oxide for the protection of human health. The site for the plant is also situated proximate to a residential suburban area. The Breathe Clean Air Group was formed by residents of that area. Its membership comprises predominantly residents of Urmston, Davyhulme and Flixton. The reasons given by the local planning authority for the refusal of planning permission are contained in the document, that's Core Documents 48. In essence, emphasis was given to the following factors. The proposed development would have a detrimental impact on the vitality and attractiveness and self-confidence of the communities within the nearby areas of Davyhulme, Flixton and Urmston, thereby prejudicing the continuing regeneration and improvement of those areas. The proposal would conflict with the development plan in place at the time being contrary to policy WD5 of the Traffic Unitary Development Plan. The proposed development raised significant concerns among nearby communities on the basis of publicly available and respectable scientific evidence about possible adverse impacts of the incineration of biomass waste, in that it would contribute to a substantial reduction in air quality in an area which is already designated an AQMA. As a result, there was a widely held objective perception substantiated by independent objective scientific evidence that the development poses an unacceptable risk to the health and safety of the public. Since the making and publication of the decision to refuse planning permission in December 2011, there have been significant changes to both national and local planning policy. At a local level, the majority of the UDP, which was in place at the time of the decision, has been superseded by the Trafford Borough Council Core Strategy in January 2012 and the Greater Manchester Joint Waste Development Plan in April 2012. Section 38(6) of the Planning and Compulsory Purchase Act 2004 provides that the determination of applications under the Planning Act shall be made in accordance with the plan unless material considerations indicate otherwise. It's not in dispute that the development plan for the purposes of the appeal comprises the North West of England Regional Spatial Strategy to 2021, the Core Strategy, the Waste Development Plan and the Safe Policies of the UDP. In accordance with Section 38(5) of the 2004 Act, where policies in the development plan conflict, the conflict must be resolved in favour of the last document to be adopted or approved or published. At the pre-inquiry meeting, the inspector indicated that the main issues for the inquiry would be the effect of the proposed development on air quality, the perception of the effect of the proposed development on human health, the effect of the proposed development on the continuing improvement and regeneration of the local area, and whether the proposal would be sustainable development as set out in the National Policy Framework, Planning Policy Framework. At paragraph 10 of the notes from the pre-inquiry meeting, the inspector invited submissions from the parties on a number of matters which included the weight to be given to various policy documents, the matters to be addressed in the environmental permit issued by the Environment Agency, and the changes to the planning policy made after the submission of proofs. These submissions are to be read in conjunction with the Breathe Clean Air Group statement of case. They address 4 specific points which complement the case of the local planning authority in objecting to the grant of planning permission. The 4 points which the Breathe Clean Air Group wishes to emphasise to the inquiry are that the proposal offends the waste hierarchy and is inconsistent with the requirement, of sustainable development. This in turn gives rise to a public perception of risk to the environment and to public health. The proposal is inconsistent with the plan requirements for combined heat and power, CHP. The proposal will give rise to a detrimental impact on public confidence, thereby prejudicing continuing regeneration. The proposal will contribute to the impairment of local air quality and give rise to a public perception of risk to the environment and to health. As reflected in the agreement as to the composition of the development plan, it's not in dispute between the parties that the Secretary of State will determine the appeal by reference to the development plan which is in place at the present date, rather than by reference to the plan which is in force in December 2011. It's also common ground that the public perception and opinion constitutes a material consideration for the purposes of Section 38(6) of the 2004 Act. Inspectors referred to the decision of the Court of Appeal in the case of Newport County Borough Council and the Secretary of State for Wales and others. 1997, Court of Appeal, Civil Division, 1894, in the neutral reference. In that case, it was affirmed by Lord Justice Hutchinson that genuine public perception of risk to health or the environment constituted a valid material consideration, irrespective of whether it was objectively well-founded by reference to expert evidence. In his decision in the same case, Lord Justice Aldous held that perceived fears of the public are a planning factor which can amount, perhaps rarely, to a good reason for refusal of planning permission. The Court rejected the submission that in order to be conclusive, public perception needed to be justified by express expert evidence which confirmed the likely absence of demonstrable harm to the environment or public health. All three Lord Justices agreed on this point, notwithstanding the majority decision of the Court on the issues before it. The issue for the person making the decision, be it the local planning authority or the Secretary of the State, is the weight to which is to be accorded to the public perception of risk to health and the environment. Each case must be addressed on its own facts and merits. Little assistance is afforded by other decisions made about other proposals for other areas. The decision as to the weight to be given to public perception of risk falls within the exercise of the discretion of the decision maker. That discretion is not circumscribed by any express set of guidelines or criteria set out in any authority. The discretion needs to be only to be exercised reasonably. The decision maker will consider the factors which give weight to the public perception of risk and those which dilute its significance as a material consideration. It's submitted that factors which will give weight to the public perception of risk to health and environment are evidence as to how widespread the perception of risk is to the local public, the nature of the perception in terms of the perceived detriment to health and the environment, the evidence which gives rise to the perception, the material local factors which are specific to the area and context in which the proposed development is to be located. These are issues consistent with the planning authority's exercise of its power and do not transgress into the areas of concern for the Environment Agency. And of the four issues set out above, I'll deal with each in turn. The site proposal is to be a wood-burning facility. The application is founded on burning in the range of 180,000 to 200,000 tonnes of wood each year. It's an additional zero which we discount there, of its operation on an availability of 90%. This availability relies on the applicant's evidence as to maintenance and closure time of the plant. The figures are set out in paragraph 3.33 of the environmental statement on which the applicant relies. The environmental statement states that 65 to 75% of the fuel stock will be waste wood, which would otherwise predominantly be sent to landfill, 30% of the fuel stock being virgin wood. Paragraph 3.34 of the environment statement avers that in order to ensure the plant's operation remains environmentally sustainable, fuel will be sourced from a number of northwest-based suppliers, minimising the distance the fuel will need to be transported. It continues that in terms of the sustainability of the fuel supply, it's noteworthy that waste wood will account for the majority of the proposed fuel. This maximises the development sustainability in reclaiming a resource which would otherwise be sent to landfill and extracting the energy potential from this material. The assertion is repeated in the planning statement in paragraphs 4.17 and 4.18. Paragraph 5.19 of the planning statement asserts the evidence has shown that 550,000 tonnes of waste arisings are available per annum in the region. Of this, 20% is considered to be clean and can be diverted to existing markets. The remaining 80% is sent to landfill, and the energy potential of this material is therefore wasted. The evidence cited by the planning statement is the 2009 WRAP Wastewood Market Report, which is core document 82. On the basis of the figures cited, the planning statement asserts that the plant would consume 32% of the available wastewood in the northwest region. In its supplementary statement, the appellant addressed the concerns raised by the GMGU about the compliance of the proposal with the waste plan and PPS 10. It was the appellant's submission that the waste plan should be given very little weight in determining the application, as in paragraph 2.17. The only reasons given for the assertion were that the primary function of the plant was not waste management, and because at the time, the supplementary statement, the waste plan was not yet part of the development plan. The supplementary statement repeated the statistics cited above as to the source and proportion of the plant's fuel stock in purported compliance with the waste hierarchy. The only evidence cited to support the submissions to the availability of the annual volume of wastewood was the same 2009 WRAP report cited in the environment statement. The Breathe Clean Air Group and other members of the local community have raised concerns about the availability of fuel source for the plant. From paragraph 3.9 of the supplementary statement, the appellant addressed the issues raised. The inspectors referred to paragraphs 3.14 and 3.47 of the document. Paragraph 3.2, the applicant confirmed that while some documents advanced by local residents illustrated the narrowing gap between supply and demand for timber, the plant will primarily generate energy using waste wood, i.e. that which is left over from other uses, which has no other function. The plant will not therefore be competing with manufacturers of timber-derived products, but will utilise material which such business cannot use. The appellant asserted that the plant would in no way be reliant on an increase in supply of timber, either from increased levels of production or importation. It's therefore evident that the appellant has firmly based its entire case in respect to sustainability and compliance with the principles of the waste hierarchy of the proposal on the supposition that the relevant type of wastewood will be available in the region in sufficient volume to meet its stated needs. This supposition is in turn founded on the data cited in the environment statement, the planning statement, and the supplementary statement. Where this data is shown to be inaccurate, or to be at significant risk of being inaccurate for the period in which the plant will be operational, or the supposition as to availability of the necessary fuel stock is shown to be questionable on a number of questions will arise about the compliance of the plant with the development plan and the nature of public perception of risk to the environment and health. The issue of the proposal's adherence to principles of the waste hierarchy are central to the determination of the application to the Planning Commission under the national framework and the local policies which compose the development plan which is now in place. In terms of the national framework, PPS 10 provides for unallocated sites that applicants should be able to demonstrate that the facility will not undermine the waste planning strategy through prejudicing movement up the waste hierarchy, to paragraph 25. The inspector has further referred to paragraph 5.15 of Mrs. Harding's proof of evidence as to the relevant provisions of PPS 10. The NPPF requires planning authorities to assess and determine development proposals by applying the presumption in favour of sustainable development, paragraph 197. The NPPF also at paragraph 7 details the function of the planning system by reference to economic, social and environmental roles, which are not to be taken in isolation and are, as paragraph 9 indicates, to be pursued towards sustainable development. In her evidence of paragraph 5.4 of her proof, Mrs. Harding describes how the core strategy has replaced the UDP. She further gives evidence that the local planning authority took into consideration the emerging core strategy in reaching its decision. The inspector is asked to accept the evidence when making its recommendation. At paragraph L6.2b, the core strategy states, the Council will require all developers of new waste management facilities within the borough to demonstrate the proposal's consistency with the principles of the waste hierarchy. L6.3 of the core strategy provides that, in determining applications for new waste management facilities within the borough, the Council will have full regard to the environmental, social and economic impacts of such development, including the scope for securing long-term benefits and providing regeneration of areas in need of investment and co-location with other employment uses. Paragraph 15.6 of the core strategy adopts the language of PPS 10 when identifying the role of the planning decision authorities planning decision-making process to provide that waste management facilities have a range of environmental, social and economic impacts which need to be taken fully into account by the planning decision-making process. The core strategy and the waste plan replace in their combination the provision of the UDP to which the local planning authority made reference in its 5th December 2011 decision. The two adopted policy documents are to be construed together in order to identify the criteria against which the Secretary of State must make its determination. The general statement of purpose contained in the waste plan provides that it is intended to provide sound spatial planning framework to deliver sustainable waste management in Greater Manchester, consistent with the national planning policies and the waste strategy for England 2007. Contrary to the submissions of the applicant, it submitted that both documents should be afforded material weight by the inspector. Of the objectives contained in the waste plan, the following are critical to the issue of sustainability. Objective 2, which requires the promotion of the movement of waste up the waste hierarchy, assuming minimisation of source, increasing reuse, recycling and recovery. Objective 6, which operates to ensure appropriate protection of the quality of life of communities. Objective 8, to reduce waste movements and where waste needs to be moved to promote the sustainable movement of waste across the sub-region. Inspectors refer to the evidence given by Mr Watson at paragraphs 104 to 116 of his proof of evidence, which illustrates the emphasis attached to compliance with the waste hierarchy in UK planning strategy and at the level of EU policy in the Waste Framework Directive. Mr Watson also illustrates the dependency of a number of industrial sectors on waste wood, which are unlikely to change because of the absence of an alternative biomass form to alleviate that dependency. That's on page 5, box 10 of his proof of evidence. Inspectors refer to Mr Watson's evidence in response to the applicant's assertions and projections contained in the environmental statement and following addendum. In particular, paragraphs 125 to 136, Mr Watson demonstrates how the figures given for wood waste arisings in the WRAP 2009 report have been misunderstood or misrepresented by the applicant, with the effect that the total wood waste arisings have been presented as the volume previously sent to landfill. The most up-to-date and reliable information in respect of the available annual wood waste available for the market, which is before the inquiry, is contained in the August 2012 DEFRA wood waste landfill restrictions in England, call for evidence, which is core document 94. Mr Singleton, in his evidence, accepted that this document contained the most recent data on the availability of waste wood for the biomass market. Although he sought to diminish the significance of the evidence in cross-examination, he accepted both that the inspector should not reject the data contained in the DEFRA document and that comparatively, of the recent documents adduced to provide information on this matter, this document was to be afforded the greatest weight. The DEFRA document, in particular figure 3, states without caveat or qualification that our most recent analysis shows approximately 0.6 million tonnes of wood waste going to landfill in England. The inspector is asked to attach critical weight to this evidence. It's corroborated in all material respects by the evidence contained in the report produced by Tolvik Consultancy in June 2011, and that's at core documents 81. Even if the DEFRA 2012 data is suggested to be provisional, the possibility that it's significantly inaccurate is highly unlikely. At worst, its inaccuracy is to allow for a very minor margin of adjustment. And even if its figures were to be increased by 25%, it would still render the applicant's predictions materially inoperative. The evidence is significant because it suggests that there is insufficient availability of waste wood of an appropriate grade going to landfill in the region to meet the needs of the plant, in accordance with the projections on which the applicant relies in its application. This evidence needs to be appreciated in the context of the other relevant factors which are material to the availability of waste wood, otherwise destined for landfill. First, the change in government subsidy arrangements, which is likely to lead to a reduced incentive to supply waste wood for biomass incineration. Second, there will be an increased competition for appropriate grade waste wood, both by either biomass incinerators planned for construction in the region and other businesses which rely on such wood for commercial recycling. It's submitted that the evidence adduced by the applicant to counter the data contained in the DEFRA 2012 document is unreliable and unconvincing. The articles exhibited to Mr Singleton's rebuttal proof at Appendix F do not supply any alternative data. Their context and provenance is unknown. The There is no evidence as to the motivation of their generation, including the possibility of political lobbying, to which their internal contents submit the possibility. They rely on anecdotal narratives which in any event do not undermine or even call into question the DEFRA data. One of the documents predates the DEFRA report. The AEA document exhibited in Appendix D of Mr. Singleton's rebuttal proof relies, as the footnote on page 2 shows, on a report produced by DEFRA and taken into consideration by DEFRA's later publication, that of core document 94. In any event, the data contained in the report does not contradict or even call into question that contained in Table 3 of the DEFRA 2012 document. It's therefore submitted that the evidence of the most recent and reliable data strongly suggests that the projections which lie at the core of the applicant's fuel intake for the plant are flawed. It's highly unlikely that there will be sufficient availability of waste wood at an appropriate grade to satisfy the applicant's fuel needs for its plant from sources otherwise destined for landfill. The possible consequences of this shortfall, each in their way, is contrary to the relevant elements of the development plan and or inform the public perception of risk to health and the environment. A shortfall in regionally based landfill destined waste wood is likely to lead to the applicant being required to source wood from remote sources or obtain waste wood which would otherwise be used for recycling in other industries or make use of lesser grade or contaminated wood. This gives rise to a material likelihood that the waste hierarchy will be offended, rendering the proposal in breach of the planning requirement for sustainability. Therefore, a justified public perception of risk in respect of the harm to the environment by the unrealistic projections advanced by the applicant. Further, the applicant's projections for emissions are based on very narrowly drawn assumptions about the plant's performance and fuel intake. There's minimal margin for variation in any one of its assumptions if its emissions predictions are to be achieved. Should just one of the relevant variables differ materially from the projection, it's a very real risk that the emissions predictions will differ from those put before the inspector. One such critical variable is the applicant's fuel source predictions by reference to regional landfill volume for waste wood. It's submitted the most up-to-date data informs public perception of risk that the plant emissions will not be as projected because it would require to rely on alternative wood grades and types from those envisaged in the environment statement. Then turn to CHP point. This is a short but significant point in relation to the provision of CHP from the plant. The proposals for the reasons previously indicated fall to be assessed in accordance with Policy 8 of the Waste Plan. This requires application of the waste management facilities to have the potential to use biogas or energy from waste-fired technologies to provide combined heat and power, unless it can be demonstrated that this would prevent the development of waste management facilities. It's a mandatory imposition. The environmental statement strongly suggests an absence of intention on the part of the applicant to meet the requirement of Policy 8 in any meaningful way. There's no credible evidence that the facilities specifications are designed to meet the requirement of Policy 8 or that the locality affords identifiable uses. Only at a late stage the applicant relied on a bare assertion unsupported by any disclosed documentation as the potential to meet the CHP requirements of Policy 8. Inspectors invited to attach little weight to the evidence that a commercially confidential document, only latterly mentioned by the applicant, contains information which is capable of addressing the mandatory requirement in Policy 8. All the available evidence points in the other direction to suggest that the applicant does not meet the requirement and for this reason offends the development plan. Prejudicial impact on continuing regeneration in affected areas, third point. The Breathe Clean Air Group makes common cause with the local planning authority in respect of the first reason for refusal of the planning permission in December 2011 decision, insofar as it's submitted that the proposed development would have a detrimental impact on the vitality, attractiveness and self-confidence of the communities of Flixton, Davyhulme and Urmston, and thereby prejudice the continuing regeneration and improvement of these areas. The Breathe Clean Air Group did not call expert planning evidence on this point, but refers the inspector to the evidence of Mrs. Harding. It submitted that the factual evidence called by Breathe Clean Air Group and that given by certain members of the public illustrates the validity of the local planning authority's decision. The inspectors referred to the history of the relevant area and the evidence given as to its recent regeneration. The development is not consistent with the spatial profile for Urmston in the core strategy. The emphasis given to the distance of 250 metres from the development to residential properties it is submitted not a point of significance in relation to the development plan. The plant will be sufficiently proximate to residential suburban areas to justify the findings in the first round for refusal for planning permission by the local planning authority. The inspectors referred to the level of public concern reflected in the thousands of letters of objection written against the proposal and the petitions containing thousands of names against the development. Evidence was given by numerous local councillors and residents that the level of objection to the proposal had mobilised public support to a greater extent than any other public issue in memory in the locality. The reasons for this are articulated in the proof of Mrs. Harding, in particular, in Chapter 6. It's noted that the public spoke with a single voice on the proposal, without any credible local voice of dissent in favour of the proposal. Evidence as to the detrimental effect on local businesses and the housing economy was not only given by Mrs. Harding, but also by Mr. Manship, in particular in the appendices to his statement. It submitted that the evidence adduced by the appellant in Appendix 3 to the proof of Mr. Singleton was ill-considered and unpersuasive. The appellant relies on a document dated 11th September 2012, produced by Mr. Colin Hetherington, to demonstrate that the proposal has not had a negative effect on the regeneration of surrounding areas. This report submitted is to be treated with considerable caution and afforded negligible weight. In both its substance and character, the report is flawed. First, Mr. Hetherington does not give requisite information as to his knowledge and experience of the relevant area. His business is located a considerable distance from the affected area, and he does not cite any familiarity with the area. Secondly, the report does not conduct even a rudimentary assessment of the basin position prior to the application for the development of the plant, against which his assessment of the post-application position can have any meaning. Third, there's evidence in cross-examination of Mr. Singleton, which struggle for obvious reasons to speak to the assertions and conclusions drawn by Mr. Hetherington. Those conclusions are fundamentally flawed in respect of each of the projects he uses as a comparator. As was made clear in the evidence given by a member of the public, Mrs. Whitelake, who gave evidence about the Barton Cross development, stated the occupant's knowledge of the plant and the incentives given to purchasers. Mr. Hetherington conducted minimal research to substantiate his assertions. Of equal significance was the character of the report. The inspectors invited to take the view that it was created more for the purposes of enabling a particular case to succeed than to assist the inquiry by an objective assessment of available information in the way to be expected of a person holding himself out as capable of delivering an expert opinion. The report does not countenance a range of views. It expressly sets itself up to demonstrate a particular premise without consideration of alternative premises, and it's selective in the data it presents without drawing attention to its selectivity. Inspectors also asked to attach weight to the evidence given in relation to the history of Urmston and Davyhulme. These are areas which have undergone significant regeneration in recent years. The fact that the spatial profile for Urmston of the core strategy is able to indicate that Urmston is no longer an area designated for need of regeneration, in contrast with its predecessor policy, indicates that recent steps have succeeded in restoring the area's vitality, attractiveness, and self-confidence to some degree, but that this is particularly vulnerable to development such as the proposal. This, it is submitted, is the appropriate context in which to view the decision reached by the local planning authority. And then I'll deal with air quality and perception of risk. The proposed site is located partly within and partly adjacent to the air quality management area. The AQMA extends from the main traffic routes of the area across residential sections of the area. The rationale for the AQMA is defined by the EU directives, which have been transposed into UK law by the air quality standard regulations, designed to limit values for nitrogen oxide. These have been legally binding in England since the 1st of January 2010. The distinguishing context in which this proposal is to be determined is that of its proximity to the AQMA and the evidence that residents of parts, if not the entirety of the AQMA, are being subjected to levels of nitrogen oxide which are in excess of the lawful limits. The recent history of the government's submission to the European Commission is in respect of the failures to comply with the terms of the directive in respect of nitrogen oxide levels is given in evidence by Mr. Dr. Holman and Mr. Watson. The relevant factor in this matter is that the area covered by the AQMA remains in breach of the relevant provisions for the nitrogen oxide levels. It's the concern of the Breathe Clean Air Group that the proposed plan will exacerbate the breach and extend the period for compliance with the directive. Even if the contribution of the plant to the levels nitrogen oxide in the area is in itself of a modest nature, and there is dispute as to its extent, that contribution needs to be weighed in the context of the already unacceptable conditions within the air quality management area. In In paragraph 2 of her proof of evidence, Dr. Holman gives evidence as to the role of the planning authority under the NPPF, citing paragraphs 102 and 109, to regulating development which contributes to unacceptable levels of pollution in a particular locality. The critical factors to which the inspector is invited to give weight in this case, are identified by Dr. Holman and Mr. Watson in their proofs of evidence. In particular, the following matters are relevant. Dr. Holman observes that the applicant has not undertaken any monitoring or modelling of the background ambient concentrations of nitrogen oxide in the affected area. The absence of either monitoring or modelling is critical because without it, the applicant is unable to know with any certainty the prevailing concentrations of nitrogen oxide in any affected area. As conceded by Mr. Oden in cross-examination, the applicant is not in a position to know with any certainty whether locations such as Tyndall Street are already in excess of the statutory levels of nitrogen oxide or whether they will be caused to exceed the statutory levels by the contribution of the plant. Dr. Holman observes that the uncertainty caused by the absence of modelling gives rise to an objective public concern as to the harmful condition of the nitrogen oxide concentrations in the affected area. The applicant elected not to undertake any background monitoring of the air quality at projected areas of likely worse concentration. There is a dispute as to which receptors are likely to be worst affected or to suffer worse background air quality. But in any event, there has been no background monitoring of any street within the AQMA by the applicant. In his evidence, Mr. Oden conceded it was a possible public perception. The reason why the applicant had not conducted monitoring was because it perceived the results would be unfavourable. Instead, the applicant elected to rely on monitoring results from the Salford-Eccles monitoring receptor and in contrast from the Liverpool Road receptor. The arguments which have ensued as to the suitability of the Salford-Eccles data as representative of Tyndall Street derive entirely from the absence of any attempts to acquire accurate data for that receptor. Similarly, the arguments which emerged in the course of the inquiry about the accuracy of the Liverpool Road receptor because of its location and proximity to trees are predicated on an absence of any attempt to acquire accurate background data for the relevant locations. In cross-examination, Mr. Oden stated it would have been relatively inexpensive to have conducted monitoring and modelling from traffic emissions of the background air condition. He gave evidence that the modelling of traffic he considered to be irrelevant because the minimal impact of the traffic increase attributable to the plant. The inspector has referred to the evidence of Dr. Holman at this point, in which he states that this misses the critical point. It's only such modelling which is capable of giving an accurate baseline comparison by which the effect of the proposal can be determined. In re-examination, Mr. Oden was invited to state that it was not reasonable for the applicant to have conducted either monitoring or modelling of the background air quality. The matrix which composed reasonableness was not explained. Cost could not have been a factor because Mr. Oden gave evidence that such steps were relatively inexpensive. Timing could not have been a factor because there was been a considerable period of time in which the data could have been obtained from the first conception of the proposal. It's not therefore understood how the suggestion that it was unreasonable to expect such work to have been performed is to be made out by the applicant. The argument of reasonableness only serves to feed the public perception that the applicant is elected not to collect data which it suspects will be detrimental to its case because it will evidence the unacceptable air quality of affected areas. There is no other credible explanation as to why air quality has been projected by comparison to other sites and not ascertained by direct assessment. Paragraphs 5 and 7 of Dr. Holman's proof are recommended to the inspector as giving the most reliable evidence to the objective basis for public concern at the likely impact of the plant proposal in the context of the uncertainty as to the pre-existing levels of nitrogen oxide concentration. Further, the inspector is asked to refer Dr. Holman's evidence given at the inquiry as to the likelihood that there are other receptors situated closer to the M16 and Tyndall Street which are likely to have nitrogen oxide concentrations similar to the Liverpool Road diffusion tubes that are likely to be representative of the worst impact of the proposal emissions. Further, public concern stems from the unconvincing evidence advanced by the applicant to establish that the plant will be capable of emission levels of 125 micrograms of nitric oxide. There's no commercially operating plant in the world which performs at this level. Mr. Watson described the technology required to achieve such an operating target as experimental because of an absence of evidence that such emissions levels have been achieved. The inspector has referred to the further clarification document CD23 provided by the applicant in respect of the information contained in Chapter 12 of the environmental statement in this regard. It submitted that the averments made by the applicant were at some very considerable distance from the contents of the correspondence and documents that used to establish the intended operating level. There's public concern that, as with the choice in comparative perceptive, the figure of 125 micrograms for nitric oxide levels has been chosen without reference to reliable data or evidence. Public perception is that data and projections have been advanced with the sole intention of supporting an argument that the percentage contribution of the relevant nitrogen oxide concentration levels will be less than 1%. The inspector has referred to the evidence of Dr. Holman on the unreliability of the applicant's evidence on this point as objective evidence of public perception of risk. As indicated in the evidence of Mr. Oaten under cross-examination, public concern is capable of being exacerbated by the knowledge of where the 125 microgram level of emission is imposed. The Environmental Agency will allow a working level of 156. Inspectors referred to the written evidence of Dr. Raab in respect of the particulates and chromium-6 emission levels, which give rise to the public perception of risk to human health. Inspectors referred both to the evidence of Mr. Watson as to the public perception of risk to human health, which was taken into consideration by the local planning authority. This evidence is asked to be viewed in the context of the sincere concerns voiced by the public, both as members of the Clean Air Group at the inquiry and in public sessions. It's submitted that the evidence of Dr. Holman and Mr. Watson gives objective and substantial evidence as to concerns about the contribution of the air condition in the area of the plant, which translates into a public concern for health, given the pre-existing detrimental condition of the air quality in the locality. It's further noted that the report of Professor Bridges, on which the applicant relies, expressly acknowledges that psychological concerns for health or the effects of living with a perceived risk can in itself constitute a clinically diagnosable impairment likely to give rise to damage. This further feeds the public concern. For these reasons, in conjunction with the submissions made by the local planning authority, which these submissions are designed to complement, the inspector is asked to recommend that the appeal be refused. Given the particular facts of the case, which are peculiar to the locality and its history of poor air quality, public perception of risk should be given considerable weight in conjunction with the other concerns about sustainability to allow the appeal to be refused.
Thank you very much, Mr. Cunnington. I think we'll take a short break before we hear from Mr. Jones. So could you just wait for 15 minutes, please?